Civil rights. One of the things we take for granted in our country is the fact that we have civil rights. Some of us don't take it for granted as much as others, particularly those who come from groups which have been denied their civil rights. It's a stain on the American experiment in democracy, what has happened to groups in the past. The only thing that would be more egregious is for us to sweep it under the rug as if it never happened. And so we discuss civil rights and what happened and vow that we won't do it again. That is part of what an education is all about. Here we go then. Civil rights. Two definitions as usual. When one group is denied access to facilities, opportunities, or services available to other groups. Your text adds this component. Powers or privileges guaranteed to individuals and protected from arbitrary removal at the hands of the government. I like your text definition better than most other definitions. Nevertheless, this idea that one group being denied to access to facilities, opportunities, and services available to other groups is a key component of that. So when we think of those privileges that are guaranteed to individuals and they are protected from arbitrary removal at the hands of the government, there's a key component in that: arbitrary removal at the hands of the government. You look at what's going on with the coronavirus COVID-19 crisis, and the economy was basically shut down overnight, or the country shuttered overnight. And that is because we had a legitimate reason to do so. Notice here, arbitrary removal at the hands of the government. This was not an arbitrary removal at the hands of the government. Now, some people during the crisis have felt that perhaps the government has gone too far. One of the reasons they're able to make that argument is because the government actually took these steps, and the crisis has not gotten as bad as predicted. And so now this pushback from individuals even within the government and from citizens themselves is a direct result of the fact that the government in the first place took action. So that is the idea here. The government can't just can't arbitrarily remove those privileges that are guaranteed, or they can't arbitrarily deny them to one group and grant them to another group. Now, there's a component of this. When we do that, when we arbitrarily deny them, or when we restrict access to services or opportunities available to one group, restrict to one group that are available to other groups, what you get is invidious discrimination. And that is discrimination against persons or groups that work to their harm and is based on animosity. So you look at what happened with African Americans in our country. Certainly that discrimination worked to their harm and was based on animosity. You can take other groups and find the same component. The Jews in Nazi Germany and other places in the world. Certainly that discrimination by the Nazis worked to their harm and was based on animosity. You saw that with the African Americans in our own country. This idea that they were less than human. And you see the vestiges or the results of that still flowing in our country today. Because this kind of discrimination is always bad. Let me give you another example here. The expression rule of thumb. You've probably heard this expression. Well, the rule of thumb is. But where does that expression come from? The rule of thumb is that we do this or we don't do that. But where does the expression itself come from? Rule of thumb. Think about that for a second. See if you know. Where in the world did that come from? Where it actually came from was an old English law which stated that a man could beat his wife couldn't beat his wife with anything wider than his thumb. Wow. Talk about invidious discrimination. And so this is the kind of thing when we say that laws don't protect or allow discrimination against one group, whether it's racial, gender, religious, or otherwise, that work to their harm and to their detriment. Now, you might think, and you may have been accustomed to this idea, that all discrimination is wrong. Nothing could be further from the truth. Nothing could be further from the truth. Here is the pertinent question regarding civil liberties. It's not whether government has the authority to treat people differently, but are the difference in treatment reasonable? For instance, should an individual that wishes to join the military, or an individual that wishes to be a firefighter, meet the same standards as all other individuals? What I've done in my class many times, obviously we can't do it online here, but I have laid down at the front of the room, I have stretched my arms over my head, and I've asked any of the young ladies in the room to drag me out the door as if the building was on fire to safety. And I've actually even had a few try, and some were able to get me a couple feet. So the question becomes, and then I've asked if there's any man who wants to do it. And I've had several take me up on the task, and particularly this one guy, he just ripped me clear out through the door. I stopped him, of course, before he got too far. He would have ripped me clear out through the door. And so the question becomes, if we have this standard that in theory discriminates against women because of their physical makeup is generally not as powerful. I want to be careful how I say this. You can tell I'm searching for the right words. There's a different dynamic to women. You look at the bone structure, you look at the muscle mass, particularly in the shoulders, and what you find is that women in general are not as physically strong as men. This does not mean they're incapable. It just means that's nature, that's reality. It does not mean that if women can't meet those same standards, they shouldn't be able to be firefighters. Indeed, they should. But there's the question: is the treatment in different people, is the treatment with reasonable? Is it reasonable to say, in order to serve in the military, you should have to do 45 push-ups to be able to get in? For a man, that's what it is. But for a woman, I don't know if it's still the case, but for a woman, it was for the time, it was only 18. Is that a reasonable difference in treatment? Are we having a double standard there? So the point being, when the government passes laws, not all laws that discriminate are not inherently bad. For instance, you can look at tax laws that say, okay, if you make above $1 million a year, you're going to pay a lot more in taxes than if you make $30,000 a year. You're going to pay a higher percentage of your tax. You're going to pay a higher percentage of your tax if you make $60,000. You're going to pay a higher percentage of your tax if you make $90,000, $100,000, $150,000, $250,000. Is that a violation of your civil rights? And the government and the courts would tell you no, that there is a reasonable difference here. People with more money, the idea is, have a greater responsibility. Society's been good to them, and because of that, they're going to pay a higher percentage of their income. The courts have ruled that this is a reasonable difference in treatment that is legal. So not all differences are going to be unconstitutional. It's got to be reasonable. I cannot emphasize that enough. All right, there are three approaches the court takes where they look at some of these issues, and we'll go through each one of these real quick. So the first is the rational basis test. Okay, I got interrupted. I had to pause this thing, so hopefully I'll remember where I'm at. I'm just going to start with the rational basis and what that is. So these three levels of judicial scrutiny that the courts will take. First one is the rational basis test, and that is legislation must be rationally related to a legitimate government end. This is a very low hurdle for the government to overcome. If it's rationally related and there's a legitimate government purpose for having this legislation, the courts will pass it. Obviously, if it doesn't violate a provision of the Constitution. Just very easy for the government to overcome this rational basis test. Then we get to the middle tier test. And that is, the government must show that the challenged classification, meaning the law that is being challenged in the court, serves an important state interest, and that the classification is at least substantially related to serving that interest. So if you go back to the rational basis test, legislation only has to be rationally related to a legitimate government end, but here it has to be substantially related to serving that interest. Okay, so some examples of suspect qualifications are gender and illegitimacy. So all the stuff that's going on right now with gender equality, this is being tried on the middle tier test. Those groups that would like to see greater rights for gender equality wish that it would tried on the strict scrutiny test. The reason they wish that is because when something is tried and the court uses the strict scrutiny test, the challenged legislation rarely stands, meaning it gets declared unconstitutional. So what is that? The government must show that the challenged classification serves a compelling, not that it's irrational, not that it's rationally rated, not that it's substantial, but a compelling state interest. And the classification is necessary to serve that interest. So suspect classifications are race, religion, and national origin. As soon as you challenge something based on race, religion, or national origin, it's going to have this strict scrutiny test. And when it has that, it's very difficult for the government to overcome this high hurdle that the court has established in this strict scrutiny test. This does not mean it can't ever be met. For example, there's a case during World War II known as Korematsu versus United States. This was a Japanese internment camp case, in which after the attack on Pearl Harbor in California, the United States rounded up the Japanese American men and placed them in internment camps, fearing that they might be hostile to the United States war effort or saboteurs. We just didn't know, and they challenged it, and the court supported the government. They said this was a compelling state interest. Our very life was at stake, and the government felt, and the court agreed that it was necessary to serve that interest, and so it passed. Now, again, these were extraordinary circumstances. It's usually not the case that happens. And so now, with that as a backdrop, we will move on our next video. We will move to the Black Predicament and go through some of the things that happen with civil rights within the Black community.